Hi, Gareth. Gareth, this 2010 order, right? There's absolutely no notice given on legislation website that this has been repealed at all. And I question whether it has been repealed or not. You're claiming that you've checked up on it and you're claiming that they've said it's repealed, right? But how do we know that they're not just lying, right? Where is the date? If you're going to say I checked and something's repealed, why not reply and say, I checked, it's repealed by so-and-so minister on so-and-so date, and show us the evidence that it's been repealed? Because otherwise, I don't think MPs like the Act, and they might just be repealing it through a backhander, or just repealing it now and saying, it's already been repealed ages ago, right? And even if it has been repealed, right, it's only an order anyway, and it's 2010. Now, firstly, there are two things on this, right? Firstly, any act in law that has ever existed and even been repealed, right, it can be used in evidence in a court, particularly for defence, that it was the law and that it existed and that there's a legal basis in law for it existed, and it can actually be used in a court, right, for defence law. And also, it's actually a standard that was set. So even if it isn't the law anymore, you can still say, well, it was the law and the government had these standards and it had them for a reason, and why shouldn't you volunteer to act based on those standards? So it's basically offered in this petition to Senedd now as a piece of evidence. Why not act? Because we've got 5%, and that was a figure which you would act on. So why not act on it, right? You can act on it. Nothing says you. It's only that before they had to, right? But this is what I think. Now, this is actually what's happened, right? They've made this in 2010. Now, the year later, a year after, in 2011, they make this. Now, this act hasn't been repealed. Now, this act, what's the title of the act? The title is, it's for local authorities, referendums and petitions, England, Regulations 2011. So not just petitions, but referendums as well. Now, let's go back to the title of the other one. The title of it is the Local Authorities Petitions England Order 2010, not Local Authorities Petitions and Referendums, right? Now, is this act only if you petition about a particular subject matter? Like, I want to change the tax on tampons, or I want a new road or highway making, or, I want, whatever you want, whether it's local or national, right? It says local government, right? So we'll go for things you can ask a local government: have new trees in a park, have a new sports centre, stop someone turning a field into a landfill site, whatever, right? You can choose the subject because it's a petition, and that's what you do in a petition. You choose a subject, and you've got the right to subject because it's the right of the subjects to petition the king, right? And you could do it even before then, but that actually makes it a legal right of way to do it. You can't be stopped from doing it. It's not there to create petitioning. It's there to stop other people from stopping you petitioning or prosecuting you for it or holding you to any commitments, right, including imprisonment, right? The title's exactly the same. The Local Authorities Petitions England Order 2010. It can be about any matter or subject you want to do with a local council, not one particular thing. And that's the title, Local Authorities. So local authorities, any petition about anything. Now let's go back to the other act, right? Now here we are with the other act, right? And I know that you know where I'm going with this, right? I know that you know where I'm going with this conversation. The title's exactly the same. It doesn't say the local authority is a specific thing, act, right? It says the local authorities, referendums and petitions, Regulations 2011. So, local authorities, still like the previous one, but as well as petitions, it's also referendums as well. Now, how could it possibly mean being anything else like the other previous order without the addition of referendums being the result of them, right? And when you read the Act, it's laying out a model, a complete model, which is perfectly compatible with the 2010 order, which is for any subject. Yet it adds into it, right? It adds into it that you get a referendum from the Secretary of State. Now, the other Act said that the local authorities could not make a decision if you get 5%. They weren't allowed to. But it didn't say that you were guaranteed a referendum, right, if you got the 5%. Now, this Act actually is more extensive because not only, well, it doesn't explicitly say that the local authorities cannot make a decision on it, but it says that if you get 5%, then the Secretary of State is meant to give you a referendum on it, right? So what it's actually doing is saying that, rather than if any local area gets 5% of the signatures or more, well, they can't make a decision, it'll go to Parliament. All it's doing is to save Parliament the trouble of debating it, to save the Parliament the trouble of wasting time in the chamber and debating it between parties or even putting it to a committee. They're saying, hey, I'll tell you what, the Secretary of State will just give you a referendum on it, right? How's that of a good deal, right? Or the Secretary of State, the head of the council, will get the Secretary of State to give you a referendum. Now, that's brilliant, right? But what this Act does is, in all this framework, and by the way, this is not the only framework, this is a complementary and additional to the normal core functioning of petitioning the government and asking them for whatever you want, right? Which they can't stop you from doing. And no law prevents you from asking for anything and prevents them from acting. What this is, all that this is doing is saying, hey, we've also got this, right? Now, if you get a certain amount of signatures, we'll do this. Or you can have that, right? Okay? Now, the only problem with this Act is that it's saying that this Act, it's using a change of governance as an example of the thing that you're asking for, right? So all is compatible and the same as with the previous 2010 order, when you can ask for anything you want. And what they're doing with this is they're saying, oh, well, it's actually, we're saying it's, for petitions asking for a change in governance, right? When you want to change the governance of the council. So are you telling me, right, that on a blank sheet of paper, under the rights and liberties of the subject, the only thing that you could possibly petition for and ask for is a change of governance? Absolute rubbish, right? It's using it as an example of something that you can ask for because they can't stop you for petitioning for everything. So why wouldn't this apply to absolutely anything subject you wanted to ask for? Because it applied to it in 2010. So what I think that you would try and claim is that, in 2010, they said you can petition for whatever you want, right? And then in 2011, they said, oh, no, you can't petition for whatever you want because then you might get it, right? So we're only going to let you petition for a change of governance on this 5% thing and nothing else, right? When the previous year, they said you could petition for absolutely anything. But what's the basis of petitioning is based on the right of the subjects to have free subject. They can't stop you from doing it because you can't be held to any commitments, right? So why wouldn't you be entitled to use this model for petitioning for anything or subject that you want, not just a change in governance of the council? Well, they can't stop you, right? But are they saying that, oh, well, we made this model for anything, but now we're saying that, oh, it's only for a change in governance, right? Well, actually, it is something. It's a model, it's a basis, and it's figures given, right? And it can be, even if you say that it cannot be anything except for a change in governance, right? It can't be for 20-mile-an-hour speed limits, right? It can be used for 20-mile-an-hour speed limits because nothing can say that if this applies for a change in governance, well, why don't we use that model for something else? Now, what it does say in this Act is that it's mainly concerned on the referendum part of it, right? But what it does say in this Act is that when you're asking for this change in governance and petitioning for these things, it's actually treating it like a blank sheet of paper. It actually says that when you're asking for a referendum, it says that you can propose how a referendum might be run, what rules the referendum might have. In fact, you can actually design your own referendum. And why and how is that? The reason is because it's a petition and it's a blank sheet of paper, right? When you put a bill into Parliament and say, I want to make a law to make wearing a red jacket illegal, right? Nothing exists. You're proposing legislation from scratch, from blank, right? You're making it up from nothing, right? And then if the government puts it through, it goes into effect and becomes law. What this Act is saying is that from nothing, you can even conjure up your own rules, your own referendum and how it will be run and when it will be run. And you could design it yourself, like designing an act of law. And if the council approve it and put it through, then it will go into effect and it will run how you want. That's the basis of a petition, because it's the creative freedom of process, right? Now, these models actually exist. So I've cited them in the petition, or me and Tina have, right? It doesn't matter whether they're in effect or not. We're using them as evidence that this is the standard and these were laws or these are laws and they say and do this. So why shouldn't it apply for 20-mile speed limits? Debate, discuss, right? Now you're coming back to us saying, oh, we don't understand what you're asking, or we it doesn't make sense. But then, just like the Parliament Committee, you make a suggestion like, oh, you respond with responses that understood what we were asking and make counter-arguments or alternative suggestions. If I pick up a piece of paper written in Latin and I can't understand Latin, I cannot respond to the person, right, and say, oh, I checked and this act is not in force anymore. How did you read what I were asking? Oh, well, I understood some of it. Oh, so you understood it, right? Oh, there's no mechanism to recall MPs. Well, you knew that I were asking to recall MPs then, so you understood what I were asking. What you're doing, Gareth, is you're playing dumb. You're playing dumb, and you're playing stupid. You understood every single thing on it, and you've even responded to it, right? You have replied to what I writ and what Tina writ together, right? What we put. You have responded understanding what we wrote. You knew what we were asking. Now, what you're trying to make out is you're trying to make out that you won't let us say it how we want to say it, right? That is like AI predictive text. It's telling you what you're going to write and how you're going to write it. And that's not how petitions work, right? It's a prayer from an individual person with a request from a blank sheet of paper with something that they want to ask for, which may not yet exist or has not yet happened, right? And the particulars of it can be debated and decided in the debate, but you don't even want to debate it. In fact, you're actually bringing the debate out of the Senedd into the person's house on whether you want to entertain it or not, right? The ancient rules of Parliament for petitions is that it has to be written in English and you have to be able to understand the letter in the letters, right? Now we've got keyboards which actually are all... You can't pick up a pen and do a scribble on it that no one can understand because the letters are permanently fixed on the keyboard, right? A, B, C, E, D. You can't say, I don't know that's a letter E and I don't know that's a letter D, right? Everyone goes to school and learns English, so you can't not know what it says. You're wanting it to be said in a particular way, how you want it to be said, and what you want it really to say and what you really don't want it to say, right? And that is manipulating an expression, how it's expressed, right? You don't have a right to dictate how people express themselves. In a court, you're trying to beat the prosecutor, right? Your defendant is trying to beat them and win. How you say it and what you say depends on if you win or lose, right? And what points you want to make. And a prosecutor comes in with very pertinent questions, which if he does not, he's got to convince a jury in a certain way, right? If everyone says, oh, don't say it like that, right? Or we don't know this or that, he might not convince them, right? So the Senedd is actually meant to be impartial. We are trying to make the point and prove the case, and we decide what is the strongest way to say it or the most pertinent way to say it. And if we lose the debate, then that's our problem, right? We lost, but you're not even letting it get in the debate. And there's a lot more extensive things get into court cases than what get on put on the Senedd. You're trying to interfere with our evidence and how we want to express it and what we want to include in the debate, which is entirely debatable, right? That's when you can add extra things in, when the Senedd can add extra things in, right, to what we've put. They don't even want to basically entertain our evidence or any position or anything, right? So there is a legal right to it. And as for understanding the figures that we've put, right, these are the figures, right, that we've calculated. And I've sent it in an email. This is all the percentages of how many people in every single Senedd electorate have the percentage of everyone who signed that 20 mile an hour petition, right? All the numbers. And I worked out averages from it. What's the average number of signatures? Typically, when you add all of the signatures up and divide them by all of the counties, what's the average percentage, right? And it's over 10%. That's how we worked it out. And the exact same people have signed. Right, now, we're not going to be able to attach this photo to the petition, right? Because unless I put some kind of link or something to a Google Drive or image upload, and you probably won't accept it then anyway, right? This is a photograph because I wrote it down on paper. It's a photograph of the writing on paper, right? Those figures that we calculated from the 20 mile an hour petition, I calculated the average. And the average is that in the Senedd, there were around 40 areas in the Senedd, right? And the average number of electors, right, for a given random Senedd area is 59,747. And in the 20-mile-an-hour petition, the average number of signatures for any given constituency under a Senedd MS is 18.2%, right? So on average, any average given Senedd constituency, 18.2% people have signed, right? That's well over double the amount of 5%, right? Now, the exact same electors who have signed that petition and they're asking for the very same thing to His Majesty the King's Senedd government, right? If you put them, rearrange those same people into their local council area, then the average, there are 22 areas. On average, any given Welsh council area has 107,064 electors, and they're the exact same people. Then they're the very same people under the Senedd ones, right, asking for the very same thing. And on average, even more have actually signed the petition if you isolate them into local council areas. 32.6%, right, of any given Welsh council area on average, 32.6% has signed that petition, right? Now that is 5, 10, 15, 20, 25, 30. That's like 6 times as many required in that 2010 order, right, to prevent it being decided by the local council. Whether it's the law or not, we're talking about the model. And why would a government enact a law like that 2010 order? Why would the English government enact it? Because it was a standard to work to. It was something expected. They're basically saying that's a large amount of signatures. If that many people are that concerned about something, then the local council shouldn't decide it, right? That's what they're saying. And that's what we're offering up as evidence. But we shouldn't have to write all this out in the petition. There's not enough word. You don't allow us enough words to write all this out. It's common sense. We've abbreviated it down. We've put simply 10 to 30%, right, in an average area of Wales of signed, because we worked it out. It's that they're the figures. They're what the figures are. How does it not make sense? They're the figures. We work them out. We're telling you what they are, right? They can be calculated. If you don't believe us, or when you get round to debating it, then, you say, well, we're asking for the evidence. Send us those figures in that you got, right? You don't want to entertain it. That's the thing. And the other point is this, right? You're claiming that you don't know what we're asking. Now, Jamie Stone's done this as well, right? He made a statement in email, it's not clear what you're asking. And then he proceeded to give me an alternative petition, which I could do, right? With a suggestion of exactly what I was asking, right? But in his words, how he wanted me to ask for it. So what he said is, I don't know what you're asking for. And then he proceeded to tell me what I asked for in different words. How did he get what I asked for from my words into his words, right? If he didn't understand what I was asking for. He did understand it. He didn't want me to say it in those words. And regardless of if he thinks that it would be or would not be better said this way or that way, I don't want it said that way. I want it said the way that I want to say it, because it's got more impact and makes a stronger point, right? It's got no swear words in it. There's not one swear word or foul language in the petition. All letters on the keyboard are in English. It's in the English language. He understood what I said because he reiterated it back to me and turned it into another alternative way of putting it. So he knew what I was asking in the first place. It's beyond standards. It is coercion. It is manipulation. You're trying to be the commander of people's freedom of speech, right? It's beyond standards. You're actually trying to control people's self-expression, what they're asking for and how they ask for it. In any civilization, that is a regime. I'll tell you how you will ask for something, right? But there's no swearing in it. There's no swearing. In a country where people don't swear, they don't use the F word, they don't use the C word, right? You're still further trying to change it like AI when it's clear what we're asking for. And this is the fact, right? If 1,000 people sign a petition, they clearly knew what it was asking for, or else they wouldn't have signed it if they can see it. 1,000 people signing a petition is evidence that they know what is being asked for. And if you don't understand it, then you're the person who isn't up to standards, particularly if there are professors who have signed it. Now, you're not even letting people get the signatures, which also prove that people not only support it, but they understand what is being asked, and therefore you need to understand it, study, and get up to their standards, right? Now, the Tumultuous Petitioning Act had a law up to 1986 which said that only 20 people can sign a petition unless you get consent from a court. If more than 20 people sign it, you have to get consent from a court, right, to petition. Now, if the act was still in effect, you could say, we're not letting you get any more signatures on this petition, right? But it's not in effect anymore. The act's been repealed. So there's no legal basis to prevent anyone getting over 20 signatures or requiring any consent from any court or the Senedd. The Senedd can. We don't need consent from the Senedd to collect over 20 signatures, right? Because it is the right of the subjects to petition the king, and all prosecutions and commitments by the Senedd and the king. Never mind the courts not letting you get more than 20 signatures unless they say. Never mind the Senedd not letting you get 20 signatures. The king cannot stop you going round and collecting 1,000 signatures. The king cannot stop you. The king cannot stop you collecting 1,000 signatures. So how can the Senedd members stop you? How can the Senedd members? How can they refuse it? How can the Petitions Committee stop you from getting the signatures when even the king cannot? Right? Since that 1661 Act was repealed, no one needs consent to collect the signatures, right? It's a legal process of law. It is bringing proceedings. It's a judicial process with evidence, statements, and a prayer on it, right? The wording is what we want to put on it, what we're trying on it. And if you don't want people to be collecting signatures to prove that they actually know what it's asking, because that's what it also proves. Those signatures are proof that people understand it. Those signatures are proof that it is up to standards, right? And you're actually stopping us getting the evidence to prove that people even understand what it says, right? That's the important thing. And we're being obstructed. This is bureaucrats running government. Bureaucrats in government taking over function of government. It is explicitly clear what those petitions say. And we don't say that it's anything other than an example. This is an example of an act. This act said this or that. It doesn't matter if it's enforced anymore, or enforced in Wales or England. And the 2011 Act updates the 2010 Act with essentially the say it updates that model and basis. And I don't think that you have to use those acts for a change of governance, because they know that you can ask for any process of referendum that you want. Why? Because it's a petition. Because the petition is free form. You can ask for what you want. Why would you be able to why would you be able to design your own referendum and have it run how you wanted if the council approve it, right? But you can't choose what subject you want on the petition, right? Why would you be able to design your own referendum from scratch, right? But not choose what the referendum's about? What they're doing with these acts is they're toying with us, right? And they're messing around with us, because they actually make something and it's actually really good, and then they realise it's too good, and then they realise that the Labour Party and the Conservative Party are actually losing control, and the people are actually that's democracy, and they're actually trying to take it away from us. Democracy, right? Those two petitions that were submitted by me and Tina, right, together, there's nothing wrong with them at all. And they need to be published.